Hey everyone. So I was just kind of sitting back, because it's not far off midnight at my time, and I was looking out for Judge Lyman, expecting him to come up with some kind of ruling on where he's going to land with Blake Lively's request for an extension of time for her for the motion for continued sealing that she wants to file. And miraculously, though, while she does not have time to file that motion, she does have time to file yet another motion for sanctions. And yes, you heard me right. Another motion for sanctions. This is a new one. This is not a supplemental to one that we've already seen. This is a whole new one. It's against the lawyers regarding their conduct at depositions. Now, in this one, she is wanting the sanctions imposed on Brian Friedman and Kevin Fritz. But in the additional letter that she attaches, a letter that she sent to the Wayfarer Council, she actually complains about Ellen and there's someone else, Kim, the two female attorneys. She doesn't mention, if I remember correctly, we'll get to it because I'm going to read it anyway, but from my very quick cursory reading, she didn't actually mention Friedman and Fritz. The letter writing to the lawyers to complain about their conduct was about two female lawyers. So it's like, what? Anyway, let's just read into this now. You're going to be annoyed. You're going to be really, really fucking annoyed because I am. So, and I know that people get quite passionate about this, rightly so. So, Blake, I don't have time to file a motion. Lively has filed another pointless motion for sanctions. What are we on now? 8? All right. Dear Judge Lyman, Plaintiff Blake Lively respectfully moves for an order for 1. Imposing sanctions on 2 defendants' attorneys, Brian Friedman and Kevin Fritz, for conduct that impeded, delayed, and frustrated the fair examination of one of their designated experts, Nicole Alexander, during her deposition on December 15th. 2. Compelling Miss Alexander to sit for an additional deposition of up to 1 hour to answer questions at Fritz, and then it's redacted. There's a hell of a lot redacted, by the way. There's a footnote. Ms. Lively respectfully asks the court to limit the supplemental deposition to questioning by her counsel, so defendants do not inure benefit from their own misconduct. So she wants, this is an out of state, I believe out of state anyway, expert, and she wants to either drag themselves or drag this expert for 1 hour. Hopefully they would do it over Zoom in that situation, because that just seems ridiculous. Okay. 3, assigning all reasonable fees and costs for the supplemental deposition, of course, there we go, to opposing counsel whose conduct necessitated this relief. And 4, awarding plaintiff half of its reasonable expenses and attorney's fees incurred in connection with the deposition and this motion. Opposing counsel's improper behaviour began less than 20 minutes into the deposition. Ms. Alexander began to testify, and then it's redacted a lot. Mr. Fritz continued to, and then there's it's redacted, but we do have a bit of a footnote here. The transcript does not support Mr. Fritz's characterization of redacted to the court, nor his representation that counsel for Miss Lively redacted asked about the redacted that necessitated rescheduling the deposition. Okay. I'm just okay. Mr. Fritz demanded that redacted. Mr. Fritz demanded Mr. Fritz redacted, which necessitated judicial intervention. Okay. So obviously, there's a hell of a lot of context missing here. We don't know what was said, what happened. We don't know much about this judicial intervention. We know that there was a hearing. When was that hearing again? Let me just double check. Sorry, just bear with me a second. I'm just looking to see what date the hearing was. Yeah, it was on the 9th. Okay, so stuff has happened by sounds of it behind the scenes we have not seen. Okay. Because this behavior is part of an ongoing pattern of deposition misconduct, the court should sanction Mr. Friedman and Mr. Fritz for redacted. Even if timing were not dispositive, redacted. If arguendo, Mr. Fritz redacted. This type of disruptive, the footnote is also redacted. This type of disruptive behavior by opposing counsel is part of an unfortunate pattern. Throughout discovery, multiple defense counsel insisted on making speaking objections, often in depositions they were not defending, and consuming time on the record to demean and orate. Ms. Lively's attorneys consistently asked opposing counsel to stop, including by letter on September 29th, highlighting their inappropriate and unprofessional behavior, such as referring to questions as redacted, laughing on the record, and complaining that redacted, that does not redacted. Despite attempting to resolve the issue, the counsel continued. Lengthy improper speech offered with 9 minutes of questioning remaining by a member of defendant's defense team who, again, was not defending the deposition. Accordingly, the record amply supports the imposition of sanctions in connection with the deposition of Miss Alexander. Do you know, as far as redactions go on this one, they are taking the redacted. All right, so that's the request. The only thing that's not sealed here is this. This is the letter that's referred to, dated the 29th of September. Okay, counsel. We write to address the inappropriate and unprofessional behaviour that continues to be exhibited by certain counsel for the Wayfarer defendants during depositions, including during testimony of out-of-jurisdiction witnesses, whose depositions will serve as trial testimony. Specifically, we write to address 1. Attorneys repeatedly obstructing deposition testimony with speaking objections, as well as a lack of basic decorum through insulting comments, audible crosstalk, and laughter during examination, in plain violations of the Federal Rules of Civil Procedure, the Rules of Civility, and the Rules of Professional Conduct. And 2, questions concerning Miss Lively's sexual history and marital relationship in violation of Federal Rule of Evidence 412. I mean, if in fairness, if we don't have much context here, but if the lawyers are being, kind of acting unruly, being loud, cross talking, and laughing, and being generally kind of, insulting and unprofessional, then yeah, I can actually understand why she's bringing this one. This might be the one sanctions request that makes a little bit of sense, but again, I don't trust anything Lively or her counsel represent. I'm not even going to comment on the questions around her sexual history and marital relationship. We'll get to that. Okay, so first one, improper objections and unprofessional conduct. Several counsel for Wayfarer defendants, including attorneys Kim Zeldin and Ellen Garofalo, have repeatedly engaged in improper argumentative speaking objections and insulting comments, despite multiple warnings by counsel for Miss Lively and other parties, as well as non-compliant instructions not to answer. And this, I do find this slightly rich, right? Because when I saw Justin Baldoni's deposition transcript. He was questioned by Mike Gottlieb, and I found Gottlieb's kind of the questioning is quite aggressive, and he was quite I didn't like it. I did not like it at all. I found that, Gottlieb had been more professional towards other defendants, including other Wayfarer defendants. But towards Justin Baldoni, I found him quite rude and aggressive, and I didn't like it at all. Okay. So the citing case law, objection should generally be limited to the statement objection as to form and the basis for such objection, i.e. compound question or a direction not to answer as set forth in Rule 4 above. In order to avoid the use of speaking objections, courts have instructed counsel to object to a deposition question not calling for privileged information using a single word, objection, or at most a short phrase. Counsel shall refrain from making speaking objections when defending depositions. Objections as to the form of the question shall be made by opposing counsel, who shall simply state objection. The objecting counsel shall not speak any additional words concerning the basis of the objection unless a clarification is requested. Okay. For example, during the September 12th deposition of Wayfarer President Tara Hanks, Attorney Zeldin, who defended the witness, engaged in improper speaking objections, insulted the examining attorney, and improperly instructed the witness not to answer based on relevance and/or form. The following are just a few of the many examples of Attorney Zeldin's misconduct, the deposition. Right, okay. I'm just going to read the quotes. I would appreciate if you'd ask a decent question. Right. Objection as to form. That's not what the document says. Please stop this. This is crazy, and I'm very tired of you too. Well, that last one, I'm very tired of you too. That sounds like someone has already said to her, I'm tired of you. Like, and she's going, yeah, I'm tired of you too. And this is what I mean about Libraries Council. Like, there's something, there's the other half of the story. There's like one half of the story, and then there's the truth. Objection as to form. You're asking her to assume 4 or 5 things. No, I will instruct her not to answer if you continue to badger the witness. You are, because this witness does not know when the darn article was published. You're asking her to assume it was published at a certain time. Assume this, assume that. Why are you asking the question? Why are you asking the witness that question? Why? Okay. You've asked this question 5 times. Instruct you not to answer. Go on. No, that's not what she said. Objection as to form. Instruction not to answer. Stop this. I've had enough too. I've really had enough. You've asked the same question 10 times. These things they're not like, from what I know, because obviously the UK doesn't use depositions. So from other I've seen these kind of objections and these kind of comments made, like in Johnny Depp, in Johnny Depp and Amber Heard's depositions, their original ones from 2016, that are, you can find them quite easily on YouTube. You see the lawyers having these kind of back and forth, with similar things, and no one's raised concerns or filed for sanctions. I mean, I don't see what's overly insulting about this. And the judge will just it'll get cut, like because the judge will go through each kind of question and answer. Any objections, that he will look at them, and then he will decide whether he, sustains or and if he sustains the objection, then that question and answer gets cut. And all of this, this waffle in between as well between the counsel, that gets cut. So what gets presented at trial is more streamlined. Okay. In addition, during that same deposition, Attorney Zeldin engaged in concerning off-record behaviour that has threatened to impact witness testimony. Specifically, Attorney Zeldin openly discussed an exhibit that was previously introduced during Miss Hank's deposition while in the presence of the witness. Specifically, counsel for the Jones parties examined the witness regarding a social media video that was the topic of discussion amongst the Wayfarer defendants in a text thread, which concludes with Miss Coslow writing, "Let us chat to Jed Wallace as well as on this." In that video, a woman... oh, here we go. This is why this has been filed, right? This is all PR. In that video, a woman recounted an incident that she alleged to have had with Mr. Baldoni when she was a 19-year-old student. They just needed to, file something at this point in time. I'm not saying that what they're saying was not valid, but, the timing of this, like, you look at this letter, why did they not file for sanctions for this? Well, now we know. I think it's to do with timing myself. I think it's to do with timing. And, they're now able to request sanctions against Friedman, which they love doing, whilst also throwing in this letter, which just happens to have that sentence. All right, okay. Following introduction and playing of that video, Attorney Zeldin made repeated speaking objections and also improperly instructed her client not to answer. Attorney Zeldin, for example, stated objection as to form, instruction not to answer, on the basis that you're giving her an incomplete hypothetical. Where are the rest of the facts? You've established nothing through that video and said, okay, now I'm instructing you not to answer. You go and talk to the judge about it. You're done. During a break in the questioning, Attorney Zeldin then suggested in front of the witness that the video in question had been created by a drug-addled teenager and openly questioned its relevance as well as the veracity of the questions with respect to the same. Attorney Garofalo engaged in similarly obstructive and insulting conduct during the deposition of another out-of-state witness, Anne Carroll. Can't remember if that's the makeup or the hair. She's one of them, I'm sure. Lively's, I mean. Whose deposition testimony may be used at trial, and then it's all redacted. She's even redacted the bullet points. At one point during Miss Carroll's deposition, during questioning with respect, redacted. The foregoing conduct by Attorney Zeldin and Garofalo violates the court standards with respect to appropriate conduct of court officers, intimidates third-party witnesses, coaches party witnesses, and worst of all, impacts trial witness testimony. We demand that such conduct immediately cease. Ms. Lively currently intends to move for sanctions. Of course she did. She currently intends to move for sanctions. Now, this was in September, by the way, and she didn't move for sanctions based on this then. She waited nearly 3 months. Ms. Lively currently intends to move for sanctions based on the foregoing conduct, and if such conduct does not cease, will suspend the deposition and seek to exclude counsel from further examination. Of course she's going to do that. Compliance with Federal Rules of Evidence 412. We write further to address questions posed during certain depositions that probe into Miss Lively's sexual or romantic history. This is the bit that's going to piss people off. Which resulted in objections pursuant to Federal Rule of Evidence 412. Federal Rule of Evidence 412, also known as the Rape Shield Law, bars evidence of a sexual assault victim's sexual behavior or sexual history. She's not a sexual assault victim, by the way. Not even close. even if there was evidence of sexual harassment, that is not the same as rape or sexual assault. There is a difference, but also, and it is a significant difference, but also, you know, I mean, I've lost my trail of thought because I'm angry. But yeah, no, I mean, you know, there is literally no evidence of sexual assault. But I can't believe she's. When you think that she couldn't have got any lower by trying to invoke Section 47.1, the fact that she is trying to invoke the rape shield law is just wild. Okay, so rape shield law bars evidence of sexual assault victims' sexual behavior or sexual history unless its probative value substantially outweighs the risk of unfair prejudice or harm. This rule has been extended to victims of sexual harassment in civil cases. Well, if it has, then that's just ridiculous. That is just ridiculous. Ms. Lively's sexual and/or romantic history has no bearing on the matters at issue in this case, and we will not tolerate such examination, which will be the subject of a protective order and sanctions motions if it happens again. Should counsel for the Wayfarer defendants continue to engage in any the foregoing conduct, we will suspend the deposition at issue and promptly seek guidance from the court and reserve all available remedies. And it sounds like they may well have had to, you know, which is not unusual, suspend a deposition to seek guidance from the court. And that may be what the judicial intervention they're referring to was. Sexual history, okay, there's a point there. I mean, we don't know what was actually asked because if you look at the actual wording, right, and I love the wordsmanship here, right? There's no evidence that she was actually asked about her sexual history because if you look at the wording, it actually says that probe into Miss Lively's sexual or romantic history. At the top, if we go back up, yeah, questions concerning Miss Lively's sexual history and marital relationship. Again, we don't know because we haven't seen that deposition transcript. The marital relationship, now I do think that's fair game here. Her husband was involved in all of this. He was at one point a party as well. So I don't know. It depends what questions were asked, really. But I cannot believe she's invoking a law. No, of course I can believe it. She does. It's not the first time, but I'm just stunned that she's invoked a rape shield law. And the whole purpose for these things, right? The reason that a person's sexual history, like a victim of rape or sexual assault, right, which are, you know, they usually involve some kind of physical touching, groping, you know, whether it be anything from penetration to unwanted kissing, to, you know, slapping someone's bottom or fondling them or whatever. And it, you know, it can be a wide spectrum of physical acts. And the reason it's important not to be, you know, to be making someone's sexual history, the victim's specifically sexual history, off limits to deposition questions is because of the risk of, like, you know, unfair prejudice. Because of the, you know, unless it's actually of some value, some probative value, then asking questions about it risks unfair prejudice or harm. That is literally why this law was pulled into place. And we have, you know, there are similar rules in the UK, probably not as strong as this, because, you know, we do have sexual history does go into questioning to a point. And, as do therapy records and so on and so forth, all of that. I just, when I thought I'd seen it all tonight, right, then she drops this. I will go and check the other documents just to check. I know the deposition excerpt. Okay, we do have an exhibit 2. So this is a conference, right? So the actual deposition transcript was sealed from this is Nicole Alexander. I'm not sure who that is. I think it probably would be I think that would probably be an expert. So this is a court call. This is a deposition. This is a transcript of a court call taken during the video recorded deposition of Nicole Alexander. Okay, let's have a look. I mean, again, it starts from page 14, so there's stuff missing. So I can only give you what's here. Sounds like the court is saying, let me hear from Fritz, right? So Fritz, thank you. So there's Meryl Gabernsky is the lively counsel here. So Gabernsky, Your Honor, I just want to make one quick correction. We did not submit the 29th of September letter to the court. I misspoke. So they didn't send that letter, the one I just read about the 2 female attorneys. They did not send that to the court, despite saying they were going to file for sanctions. We submitted it to the other side. I just wanted to make sure the record is clear. The court then says, Mr. Fritz, thank you, Your Honor. Unfortunately, Ms. Gabernsky's recitation is completely inaccurate. The way the deposition started was, and then it's redacted. The court then says, what is wrong? And then something's redacted. Fritz says, that's right, but the specifics I don't believe were necessary, Your Honor. Then there was an objection, and something's redacted. The court says, with an expert, a testifying expert, I don't think that's an objection that you would enjoy with a testifying expert. Fritz, the witness testified that, and then there's a lot that is redacted. I don't even know who's talking at this. I think it's still Fritz. In the last instance, Your Honor, the witness said redacted, and then at the bottom, so this summary by Ms. Gabernsky about, and then it just cuts off there. So not an awful lot to give us, but okay. Well, I mean, there's 12 pages of this from Heath. All right, we'll just skim. So this is Shapiro. This is Alexander Shapiro. Okay. And Ezra Hudson. Ezra Hudson, are you refusing to answer questions unless you read this entire document? Shapiro, objection. Witness. I don't even know who is this. Oh, it's Jamie Heath, right? Jamie, if you're going to ask me something about a document, I just want to be able to read it. Hudson, go ahead, finish reading it. You've already read about half of it. You can finish. Jamie, no, I hadn't. I would like to read it. If you're going to ask me, I just want to understand what I'm responding to. Hudson, okay, let's go off the record. Shapiro, we're not going off the record. Hudson, I'm taking a break. Yes, we are. Shapiro, we're not going off the record. Hudson, yes, we are. Yes, we are. It's not up to you. This is my deposition. We're going to go off the record. And then Jonathan Bach, who is also there, asks how much time is left. Shapiro says, there's 6 minutes left. Oh, sorry, 7 minutes. Hudson, okay, I have 7 minutes. The videographer, 9 minutes left. Hudson, 9. There you go. We're going to take a 10-minute break. We'll come back for the last 9. Bach says, let's make a record before you go. Let's make a record. Then there's some cross talk. Hudson, not on the record, not on my time. God, they're literally quibbling over a minute or two. Back, can we go on the record? Hudson, absolutely not. Okay, you can go on the record and make any statement you want. Back, I'm going to go on the record. Hudson, but you're not taking my 9 minutes. Oh my God. You're not taking my 9 minutes to make a record. Shapiro, so you can ask more questions about a dead former client of one of the lawyers in this case? This has got to be Travis Flores. Hudson, if you want to make a Miss Shapiro, and how is that proper? Hudson, I understand that you are new to this case and you don't understand everything. Bah, I want to go on record. I don't care whether, and then there's crosstalk. Shapiro, I'm new to this case, but I'm not new to the practice of law. I've been practicing law for over 30 years. I know the rules, ma'am. Hudson, we're going off the record. I have 9 minutes left and I'm going to use them to ask some questions. If you want to make a record, you can add time and make whatever record you want. Back. Okay. Hudson, okay. Will you agree that you will? This is not counting against my 9 minutes. Back. That's fine, but I want it on the record. I want a record of what's happened. Hudson, you want a record of what's happened. Back. Yes. Hudson, you can make a record if you will. Back. I would like to, if you will let me. I'd love to have been a fly on the wall. Hudson, if I will let you, if you will agree that it's not going to impact my 9 minutes. Bah, I've already said fine to that. Do I need to say it again? Hudson, okay, you can make whatever record you want, but I'm going to take a break. Bah, okay, can we go on the record for this? Hudson, you don't need the video for this. You can just do it for the bah. I'll do it on the video. I don't need the video. The videographer, we're still on the record. After all that bitching, they were still on the record. Oh my God. Bah, are we on the record? Yeah, I just want to say we had a break less than an hour ago. So he then makes his record. We had a break less than an hour ago. We made clear to counsel that we didn't want another break, that this same witness is being deposed tomorrow, that this process is exhausting, that he's expected to testify for another 7 hours plus breaks tomorrow. She came back from a break, and part of her questioning had nothing whatsoever to do with the claims and defenses in this case. She was clearly at the point where the questioning becomes optional and rhetorical, and she engaged in a series of questions aimed to drive a wedge between this deponent and his lawyer, and to tarnish the reputation of the lawyer. That's how she has used her time. Hudson, this has nothing. Bach, excuse me, I'm making a record. I've actually got tears now because this is so funny. Hudson, then we are going to excuse the witness from the room because you are speaking and coaching the witness right now. Bach, I'm not coaching the witness at all. I don't think that's coaching the witness either. Hudson, this is totally inappropriate. You are coaching the witness. You are making a very long speaking objection. There is no purpose. There's no judge in the room. Everything that you're saying is you can make an argument about it. We're not going to do this in front of the witness. Bah, technically, a speaking objection is when there's a question pending and you object to the question. So now he's schooling her on what a speaking objection is. Hudson, no. Bach, I'm not objecting to, and then there's some crosstalk. Hudson, speaking on the record is not permitted like this. You're objecting to the break. Objection noted. We're taking a break. Bach, all right. This is silly. Yes, I 100% agree. This is silly. Hudson, okay. Bach, this is silly. Hudson, I do not want you to coach the witness anymore. And then Shapiro pipes up. We're not coaching the witness. Hudson, make other statements on the record about the witness. If you insist on doing that, the witness should leave the room, okay? Bach, I'm going to defer you in every respect. Whatever I need to do to let you make my statement on the record, I'm going to do, okay? Hudson, then you can excuse the witness from the room if you insist on making this statement. Bah. Okay, Jamie, go outside. Go outside as I continue. After we made clear our concerns about breaks, the witness is Hudson. Yeah, I would like to also note that you are not the representative lawyer. Bah. If you cut me off again, I'm going to call Judge. They've written Judge Hymen. I think they're supposed to be Lyman, but they've called him Judge Hymen. They've typed Judge Hymen. Does everyone know what a Hymen is? Hymen is the is the kind of thin bit of it's like trying to find the right words here. It's like for those who don't know, a hymen is a thin bit of tissue that covers the vagina. Um like that and you kind of perforate it then when a woman loses her virginity. I find that hilarious. This is just funny. Judge Hymen. I'm going to call him that from now on. Yeah, right. Sorry, I'm trying to compose myself, but this is just the most fun I've had with this case for a long time. If you cut me off again, I'm going to call Judge Hymen on the phone now. Hudson, you want to tell him that you, who are not defending the deposition, are wanting to make a 10-minute speaking objection. Who said it was 10 minutes? She just whinged that she had 9 minutes and no one was going to take her 9 minutes. He didn't say he was going to take 10 minutes. And he's taking this long because she keeps interrupting him. Right, Bach, can you let me speak? And then you can make whatever speech you want about me and you can say whatever you want about me, but you are going to let me. And then this crosstalk. Hudson, yeah, Mr. Bach, you are not defending this deposition. You are a participant here who has decided to make a speech on the record. Bach, we're not kids on a playground. You just said if Mr. Heath left the room, I could make my statement. That's fair. She did say that. Now you're not letting me make my statement. Can I make my statement? Hudson, you can make your statement over my objection, okay? That you, Bach, just let me know when I can make my Hudson, you should, Bach, statement. I'm just going to sit here and not say, Hudson, you should not be making any statement on the record. Bach, anything until you tell me I can make my statement. This is them kind of speaking over each other now. Hudson, if you are disrupting the deposition in order to make a statement as a non-dependent lawyer in this deposition, Bach, are you done? Hudson, and I don't agree. I excuse the witness. If you want to continue, I'm just going to let you do this so we can finish this deposition, and then we're going to take a break, and we're going to take our last 9 minutes. So if you want to make the statement for whatever reason, go ahead. Bach, are you done? Hudson, I'm done. Bach, okay, can I talk? Hudson, you can talk. Bach, okay. As I've been saying, after we've made clear that we're concerned about the breaks, we're concerned about the witness being tired, the next line of question had nothing to do with the case, but simply to do with the client and his lawyer and trying to drive a wedge. And now the questioning lawyer wants to take yet another break. It's clear from the content of her questioning that she's no longer focused on the merits of the case and that she's conducted her substantive questioning. I don't see the need for another break. Yeah, I don't see the need for a break when there's only 9 frigging minutes left. I think the deposition is practically over. The client is tired and has to go tomorrow. I think this is abusive. I think this is unnecessary and I object. Hudson, all right, 10 minutes, off record, thank you. Yeah, I think that's just absolutely stupid. We've only got 10 minutes of a deposition left. There's absolutely no need for that. Okay, yeah, I'll just to show the Alexander deposition is filed under seal. The Fromholtz one as well, you can only get it on PaySub, but I've already had a look and that is under seal too. At the time I'm recording this anyway. Okay, so yeah, we're still waiting for Lyman to make a decision on the motion for whether Lively is going to, is allowed an extension of time over the continued sealing or not. Right, okay. If something new hits, I will try to get to it, but it is now it's gone midnight my time, so I may have to do it either tomorrow or, at some point on the weekend. If we do get a ruling from Judge Lyman, though, and I'm still awake for that, I will come on and do the briefest of brief videos just to say, what he's decided. But I'm anticipating him to go with Wayfarer. I really do. I think they've offered a fair compromise. And in the meeting, Wayfarer kind of cite that, that he was kind of amenable to a short extension, which is what they were, which makes sense now as to why they offered, those extra 10 days in the first place, because Lyman had kind of hinted that, if a few extra days were needed, then that would be acceptable. What is not acceptable is that Lively is asking for 2.5 weeks and eating into Wayfarer's time to respond. There are effectively, multiple parties who are going to be filing objections. It's going to be rolled into one motion. There are at least 15 third parties. Wayfarer have got to respond to all of that, and Lively is taken away from their time, and it's not playing fair. I'm not blind. I can see what's going on. There's also stuff like, I think, PR driven as well, like, getting in there about an alleged encounter with Justin Baldoni and a teenage girl. And the rape shield law. I mean, for goodness sake. Anyway, so yeah, I'm gonna leave it there. We'll wait for Judge Hymen. Have a good night, guys, if I don't speak to you later.